Hello and welcome to the Middle East Forum Speaker Webinar Series. I'm Stacey Roman and I will be moderating this discussion today. We're pleased to have Member of Knesset, Michal Cotler-Wunsh, appointed as Knesset's representative on issues related to International Criminal Court. Join us to discuss, is the ICC prosecuting or persecuting Israel, and does it matter? Ms. Cotler-Wunsh will speak for 15 minutes and open it up for questions. Should you wish to ask a question, please use the Q&A box located at the bottom of your screen to type out your question. And with that, I will turn the discussion over to MK Michal Cotler-Wunsh.
Hi, everybody. Thank you. I can't actually see anybody, so I hope you can see me and hear me. I'd love an indication that that is the case.
Yes, that is the case.
Perfect. Thank you. Okay. How are you? Okay, terrific. So thank you very much. I really wanted to start with, first of all, with the title. And, you know, everything is in the title. I think that it's very important, or at least from my perspective, that we engage with this topic from the perspective of, is it important at all to address the issue of the International Criminal Court, specifically with regard to Israel, specifically with regards to the decision that we are awaiting, that the ICC is meant to be rendering with regards to the possibility or probability of prosecuting Israel or persecuting Israel. We can take it either which way. The title addresses both. For those that are familiar with the topic, you know that you know, we're awaiting this decision that the prosecutor will decide if indeed she can prosecute the state of Israel. And I would like to address this as an opportunity that I think both in the international arena we have a role to play, and internally within the state of Israel. So maybe I'll begin within with you know, in the international front and with the international arena, and address the issue of the decision which we are awaiting, and maybe we would be better off to have this discussion after it's actually rendered. But in anticipation of that decision, there are a few things that I think we should keep in mind regardless. First of all, as most or some of you may know, the state of Israel is not party to the Rome Statute. So the question of whether the Palestinians can legitimately call for an investigation and where their jurisdiction lies, you know, awaits the decision and the prosecutor's explanation for both actually issues. You know, how do we address those? A decision to investigate the state of Israel, assuming that the prosecutor does decide that that's indeed within the mandate of the ICC, would undermine legal experts and opinions and amici briefs, by the way, to the court by numerous Western countries. I think that that is another issue that must be addressed, raised with the international community, and addressed as we engage in the conversation going forward. It's also a precedent as far as a legal precedent is concerned. I think that that should concern not only the state of Israel, if the decision rendered would be indeed to prosecute, but also should concern all of the countries involved that, you know, presented their positions and presented these legal opinions, and they would essentially be undermined. Of course, there's the issue of complementarity. Once again, this relates to the state of Israel for sure, as you know, is internationally accepted. There is an excellent rule of law and system of law in the state of Israel. The courts, indeed, and the concept of complementarity leans on the internal court system and the rule of law that exists in Israel, as it does in other countries. This wouldn't only affect the state of Israel, and I would argue all countries relying on complementarity should be concerned were the prosecutor to decide that despite complementarity, despite the existence of a functioning legal system, well-renowned legal system, the prosecutor would, you know, overlook or undermine the principle of complementarity as well. With regards to the international community, once again, I would say that the decision to prosecute the State of Israel also needs to be addressed from the perspective of the ICC's actual role. If we go back to the mission, vision, and values of the ICC and the scarce resources that it has, the decision to persecute or prosecute the State of Israel in this context is actually, instead of fulfilling its mandate, fulfilling the vision, mission, and values, using or allocating limited resources to this investigation. And by the way, it's already taken up much of the court's resources. And, I guess, I would say, instead of investigating what it should be investigating with regards to what's happening in the rest of the world, whether it be the Uyghurs in China, whether it be cases of the people in Venezuela, whether it's women in Iran that are being ignored by the very same court, mandated by the very same international community to investigate those crimes against humanity. So again, I think that these are all cases for the international community to be concerned by, not just the State of Israel. And certainly in terms of the founding principles of this court, and I would say the power and the pity. The power in terms of what it was meant to do, and the pity in terms of what it is doing and would be doing were it to decide to prosecute the State of Israel. Then maybe I'll turn internally, and perhaps my role as appointed officially by the Knesset to the topic of the ICC, not to be a representative to the ICC, that isn't the purpose at all. It's both to engage with my peers in an interparliamentary way, officially and unofficially, with regards to everything that I began with, the prospective decision and whatever it will be, the grave concern that the international community should have, and maybe even the imperative, or not maybe, the imperative and the possibility to reform the ICC so that it can fulfill its original mandate, vision, mission, values that I referred to, but also internally. And I think internally, when I say, I mean within Knesset and within the State of Israel, within decision-making, committees that are relevant to this topic. And I'd say the ICC is really just a microcosm of the argument that I have been making in all kinds of other contexts for several years with regards to the imperative for the State of Israel to rise from the docket of the accused, and to do that by affirming the language of rights and utilizing the very same tools that are available in international law and I'd say both our friends, our allies, and our foes utilize regularly, whereas the State of Israel has actually been in absentia. So when I say to speak the language of rights, I do not mean English. I'm referring, of course, to the lingua franca that the rest of the world, free world at least, actually not only free world, utilizes, and many have chosen to utilize this language of rights, I would say cynically, to undermine the very same rights that were meant to be upheld, promoted, and protected. Internally, within Israel, I don't think that around the decision-making tables there's enough of an understanding, and actually my role in the capacity that I'm very grateful that acknowledges the importance of having a voice within Knesset to make representations internally to my peers within Knesset, so that when we sit around the decision-making tables, we are aware of Israel's challenges in the international arena. As I say, this is just, I think, just one symptom of the many challenges that Israel faces, but quite a big one, and a strategic challenge to the State of Israel in terms of the battle for public opinion, which was waged. And I yesterday actually at a committee hearing referred to, Durban of 2001, where really the first implementation of the strategy launched in Durban maybe was with the movie Janine Janine in the aftermath of the allegations made against Israeli soldiers by the movie Janine Janine. But I think we see many symptoms or many other, I would say, implementations of the very same strategy to utilize the language of rights, to utilize international law in a way that actually undermines them. I think that the Goldstone report was such a case. And I think that this, the ICC, what we see now, is just a continuation of the very same battle launched, or the very same, let's call it lawfare, for lack of a better word, as opposed to a different kind of war waged against the state of Israel. And in many ways, we've been in absentia for many reasons. And actually, I don't think that it matters why. The state of Israel has been in absentia and has been sorely lacking from the arena. And in that sense, it's a losing battle, and we have to enter the arena and fight it. And so I think that this provides an opportunity, call me an optimist, but alongside this decision, whatever it'll be at the ICC, I think it is an opportunity and also a responsibility to understand internally, as I said, in the Knesset and internally in the state of Israel, and to engage with the international other parliaments or our peers around the world, and the international community, all the organizations and the countries that are trustees of human rights, that are the ones meant to uphold, protect, and maintain international law, human rights, that speak for those, or that draw their mandate from those principles of international law. I think, once again, that the opportunity that we are going to be presented with, we already are presented with it, by the way, regardless of the outcome. I wouldn't wait, even if the outcome were not to prosecute the state of Israel. I believe that it's imperative we engage in challenging these paradigms, in challenging the international community to expose the double standards that have enabled this to go on for this long, and to create this semblance of upholding and maintaining international law while really undermining its principles at the very same time. So I look forward to hearing your questions, and again, the opportunity to engage with you this evening internally within the state of Israel and within the Knesset and in the international arena is one that I think is not only imperative, but is part of my mission in Knesset, having entered recently. So thank you for the opportunity to discuss it.
Wonderful. Thank you so much. So the first question is, can you just give us a little background on what the supposed Israeli crimes in question are?
Well, the crimes in question are actually Israel's soldiers, or which would actually a very broad number of soldiers, or an extensive, I would say, number of soldiers, from the very high-ranking officers to the lowest-ranking soldier that executed commands. It is an army, after all, and is a hierarchy for violations of international law, for grave crimes against humanity committed very specifically. And by the way, the mandate to examine, beginning on a very certain date, actually right around Operation Protective Edge, gives me an opportunity to also address this from another perspective, or another principle, foundational principle of international law. That is the principle of reciprocity, because in the same war or Operation Protective Edge, actually 2 Israeli soldiers are still held, along with 2 Israeli civilians, Hadar Golden and Oron Shaul, 2 deceased soldiers. 2 Israeli civilians, Avera Mengistu and Hisham Asayed, are still held in standing violation of international law that actually occurred at the very same time, or just before, the mandated period of reviewing Israel's alleged crimes against humanity and breaches of international law, violations of international law. And I think it's fundamentally exposes the double standard, and imperative that we understand and address that. In fact, the very same court that's meant, or may decide to prosecute the state of Israel, has not even alluded or investigated for one moment this standing violation. And when I say a standing violation, and not everybody, I don't know if everybody's familiar with it, but Hadar Golden was actually abducted and killed 1 hour after the entry of an internationally brokered humanitarian ceasefire. And every day that has passed since, we are in standing violation of that internationally brokered, by the way, supported by the EU and brokered by the UN and the United States. 1 hour after it was entered, 1 hour later, it was violated, and we are in a standing violation. And when I say we, I again speak to the international community. I speak to the trustees of human rights. I speak to the ICC. I speak to the very systems that are meant to uphold, protect, and maintain international law and human rights. And so, again, another foundational principle, that of reciprocity, would be severely undermined if we were not to speak in the same sentence or in the same breath of alleged crimes against humanity or violations of international law or criminal charges cast against Israeli soldiers from the very same operation.
Thank you. If the decision goes against Israel, how vigorously supportive do you think the Western and even EU countries will be in accepting the decision or trying to invalidate it?
So, I mean, I'd sort of be foolish to answer that question because I'm not a prophet, but I'd say this. I'd say that I would call on my colleagues in parliaments around the world to stand firmly against such a decision for all of the reasons that I mentioned in my first statements regarding the international community. I don't believe this is about Israel solely. I don't believe this is Israel's issue at all. I believe that Israel's the canary in the mine shaft. And I believe that there is an opportunity and an imperative for European countries and beyond to engage with this question while exposing double standards. Now, that demands a lot of us because the opportunity for the reform of the ICC, assuming that we understand that the ICC's original role, original mandate, original mission, vision, and values on the ashes of the Holocaust was an important understanding, and that these principles, complementarity and reciprocity, these principles are fundamental to being able to engage in a world where you need some sort of understanding or uniform understanding, or at least acceptable rules to play by. If we enable them to be applied with double standards or inconsistently against one country, one people, one religion, then all people, all countries, all religions should be paying attention. And that is where I think our engagement will become very important. It's where I'm grateful for the opportunity to, at the very least, try to reach out to our peers and to inform my own peers within Knesset of the importance of engaging, because we have many formal and informal possibilities. We have interparliamentary, sort of the parliaments of the parliaments, whether it's the European Parliament, or friendship circles that are a little less formal, that we each head. I'm the Canada-Israel, friendship chair, and so forth. We not only have that possibility, but we have that responsibility to engage with our peers around the world in order to explain in this way the challenge to the entire international community, not just to the state of Israel. And so I would hope that we would be able to make a difference in that way as well.
Thank you. We have a Canada-specific question coming in. How do you expect Canada to respond or even care, especially now that Trudeau is trying to curry favor for a seat on the Security Council?
So I think that's a little bit behind us. I think Canada didn't receive a seat on the Security Council. I don't know if that'll change anything, but I would say that Canada itself actually submitted an informal amicus brief. And the amicus briefs that were submitted, as I said, if they were to be ignored by the ICC, should concern all countries. I would hope it concerns Canada even more. I think that Canada, if we speak about the power and the pity, Canada has the possibility to really shine in terms of both human rights, but not just the beacon of human rights, but the consistent application of human rights. In its own way, Canada has a role to play here that I would hope would be one that it would choose to. But regardless of, as I said, the state of Israel, if Canada's opinion were to be overlooked, if Canada's opinion were to be ignored, I think Canada would merit Canada understanding that, like as any other country, as Germany, as all the countries that submitted their own positions with regard to the Palestinian legitimacy in terms of it being a country or a state. Again, consistency is crucial if we are to, as trustees of human rights, if we are to be able to actually apply these rules consistently. And once we have the rules, we have their foundational principles, as we mentioned, complementarity, reciprocity, if they are not upheld, promoted, and protected by those very trustees of human rights, they're undermined for all of us, not just for the State of Israel.
So earlier you were discussing that Israel isn't party to the Rome Statute, and therefore bringing in the question of legitimacy of this. Can you discuss that a little further?
Well, look, and that's where we're in a bit of a, it was important to me to say I'm not the representative to the ICC. Israel doesn't have official representation to the ICC. Israel is not a state party to the Rome Statute. That has implications for the ICC itself, and for international law generally. If countries don't impose or don't join a statute, but nonetheless can be considered as members for whatever reason, in this case, in order to be prosecuted, then that has all kinds of other ramifications. In this case, I would say this. I would say once again, and I guess I'm a little bit consistent in this, the overlooking of foundational principles of international law, creating a double standard or singling out one country, we can call it persecuting, but singling out one country as opposed to all others has ramifications for the entire infrastructure, for the entire system. And so if this is just the canary in the mine shaft, once again, then that is the role with regards to the Rome Statute as well, in terms of the legality or the illegality of making that decision, and the ICC's decision as it will be rendered will have great implications and as far as I'm concerned, ramifications for the entire structure of international law, not just for the State of Israel.
So speaking of the representatives, can you give us a brief background of who has the most power within the ICC? Countries, I know basically who is the body that makes these international laws and who has the representatives within the ICC?
Well, that's first of all, that's not, from my perspective, that's far less interesting because I don't know the ICC politics. In fact, it shouldn't be political. It's a court of law. I think that herein lies the problem. Even the fact that you would ask that question, it doesn't matter. It shouldn't matter. I should say this. It shouldn't matter, and I say this as a lawyer. If it is authentically a court of law, then that question shouldn't even exist. And so I'm going to completely defer to anybody who has an opinion on that, because that would just be engaging with something that's illegitimate as far as I'm concerned. A court of law is based on legal principles. In this case, on the foundational principles of international law and human rights. In this case, there should be an appointment system, and we can discuss the appointment system to the ICC and whether it's a professional appointment system and so forth, but that's not, the discussion that we're having this evening. The reform of the ICC, maybe that I will say, the reform of the ICC is instrumental to being able to uphold, protect, and maintain both international law and human rights. And that is in the interest of all state parties to the Rome Statute and beyond. That is in the interest of the entire international community and of all countries and organizations that hold themselves as trustees to that international law and human rights.
Thank you. Can you discuss that a little further? What reforms you think should be implicated?
So I think that the reforms that should be engaged in or addressed must be addressed by the international community, by the state parties to the ICC, to the Rome Statute, and that are state members. And in that sense, I think that holding to account and taking responsibility as we aren't members, I would be overstepping my bounds in making those recommendations. I'm sure that the State of Israel, and it can be a member of some sort of a suggested reform, if that would be the track taken by the international community. But I at this moment in time, I don't believe that I have any suggestions that I would make as to the reforms, other than what I keep repeating over and over. The foundational principles of international law, the original vision, mission, and values of the ICC have to be upheld. They have to be the guiding or the infrastructure that holds this organization both to account by its members, and that it holds itself to account to. So you can't undermine the system by disregarding reciprocity, by overlooking complementarity, by not caring if a member is a state party or not, by ignoring amici briefs from countries that make legal representations and then claim to have jurisdiction. It just isn't legally sound, but it doesn't make sense. And so the reform would have to begin back with where the ICC was launched. It would have to begin with the original mission, vision, and values. And those exist, and their need, or the need for them, is more urgent than ever. I mean, in a world where the ICC was meant to ensure that never again, we see a reality of again and again. I mentioned only some of them. I mentioned Iran and China and Venezuela. But in a world that is again and again, and we look at the populations and the peoples that have no voice, that have no legal infrastructure to turn to for the protection of their rights, then we understand that that reform is more important than ever.
Wonderful. Thank you so much. And we wish you the best of luck in radicalizing the changes there. We've unfortunately come to the close of our webinar. Thank you again, Michal, for speaking with us today. For our viewers, please join us 3 p.m. Eastern for our weekly update with Ashley Perry. And thank you all for joining us. I hope you have a great day.
Thank you.
Thank
Have
you.
a great evening.